Roxo Media House.
A Signal 51 is police code for an investigation, a law enforcement proceeding that is a systemic and thorough attempt to learn the facts about a possible crime that is complex and whose facts and circumstances are generally hidden, at least initially, behind obstacles that can be coincidental and or man-made. Investigations methods are formal. I'm John Henry, a journalist. My partner is Jake White, a retired Fort Worth police sergeant. And together we examine the difficult cases of law enforcement, both in Fort Worth and around the region. This is Signal 51. The show is designed specifically for a more mature audience. Some of the content is graphic and is not intended for younger audiences. Murder at the Public Schools Gymnasium, Part 2.
So the day prior, Clark showed up for jury selection wearing his U.S. Army uniform, decorated with combat medals. The state quickly objected on the grounds it was a ploy to elicit sympathy. The defense argued it was not for sympathy, it was to avoid the misconception that Clark was a deserter. A deserter is how police described him. However, Baldwin contended Clark was not a deserter because he was at Fort Sill when the warrant was issued. Finally, you may remember Clark was arrested in February 1970. Here it is, September 1970, and Clark was still in jail. So on the same day, Judge Gray set a $3,000 bond. One would think that the logical step would be to post bond, but he did not. Clark's attorney feared that if he posted bond, he would be apprehended by U.S. Army officials. So in jail, Clark remained. 8 days later, September 16th, 1970, a surprise was in store. The surprise, the murder case, and the rape charges against Clark were dismissed. The rape charges, something we knew nothing about until they were dismissed, stemmed from a case in 1966. And in this case, and in the reports that we found, it stated Clark was indicted, but because of a lack of evidence, a warrant was never written. The case lay dormant until the death of Leatherman. Ultimately, the state told the court they did not have sufficient evidence to prosecute Clark because the witnesses changed their stories. However, Clark was still not a free man. He remained in custody. The charge, desertion. So Clark, a relatively free man in terms of criminal charges in the state of Texas, now had no worries in regards to his possible role in the death of Barry Leatherman. However, there were three other men tied to this case that could not be so sure. Clarence Earl Russell, Warren Kaczynski, and Gary Bertram Jones. The grand jury returned false swearing indictments against these three after they changed their stories. Ultimately, the shift was significant enough to where the DA's office did not believe they could successfully prosecute the case.
Now, Jake, I have the high honor and privilege of introducing a special guest. I think this might be our first special guest. I mean, a special guest.
Yeah, special.
He is Sean Firke, a real estate attorney who works for the Baker firm Fidelity National Title, a title company in Fort Worth with 7 offices across Dallas and Fort Worth. Did I get that right, Sean?
You got it.
Sean also has experience in criminal law on both sides, working for noted Tarrant County defense attorney Jeff Kearney, and after that as a prosecutor for the Travis County District Attorney's Office. Sean also worked in the State Attorney General's office. Now, last time we saw Sean, Jake, he was nursing a beaten up, ratty-looking foot.
It was bad.
It was not pretty. But Sean, we're glad to see that you appear to be well in the mend. And for our audience, Sean will be joining us periodically or perhaps more often to help us analyze legal matters that arise in cases, these legal matters that, of course, we don't have an expertise about. So, Sean, welcome to the Signal 51 Chronicles team.
Thank y'all so much. Glad to be here.
All right, Sean. So first up, one of the things that came up, this rape charge on Clark. So he's indicted in 1966. The case lays dormant as described. He's indicted, but there's no warrant. Have you experienced that? Have you seen that?
typically know. I mean, obviously he was not in custody at the time. Was he?
No.
Okay. So when a grand jury, in this case, returned the indictment, which means they found probable cause to believe that a crime, in this case rape, had been committed, they true bill it. The indictment, the formal charging instrument in a felony case, is filed. At that point, a warrant typically would have been issued for his arrest. So I find that rather strange that an indictment was returned but no warrant was issued.
Yeah, that was kind of a hard one for me to process as I read through this case. So when we look at this case, when we look at the death of Leatherman, we look at, ultimately, we're at a position to where all the charges are dropped. There were 2 suspects in custody. One confesses, recants his confession. The other one, witnesses provide witness testimony that would suggest they saw something. They saw something that led to probable cause in the minds of the investigators, who then presumably presented the warrant to a judge. The warrant signed. William Sylvester Clark's arrested. He's charged with murder. However, this one, so what was different in this one, and maybe it's still a practice today, I don't know. We have the lawyer here to ask the law questions.
Let's get him.
Let's get to this. So is it likely, or how often does it happen, or does it happen, that the defense has the ability to actually interview one of the state's witnesses?
Right. So in my experience, I was a little surprised when I learned that. In this case, obviously this was 1970, so this is going back, 50 plus years. But in my experience, both as a prosecutor and working for a criminal defense firm, we did not, when I worked for the criminal defense firm, we never were given the option to go and interview the state's witnesses. I mean, we would typically know who they are or who they were, who the state intended to call at trial, but, we didn't really go and interview them independently prior to the trial. You certainly would have an opportunity to cross-examine them on the stand during the trial. So I found that to be odd. Obviously, it's like anything, things change over the years. I don't know in this case, because of the issues that they were having with people, recanting their confessions and eyewitnesses changing their stories, if the judge, felt that it was necessary to allow, the defense, Mr. Baldwin and his team of investigators, to speak with the state witnesses. I understand that, they didn't know what they had mentioned in their interviews with police, but I did find that to be a bit peculiar because, like I said, have not encountered that in my practice.
The state gives the defense all evidence, correct? Everything that they got. There is no ace of spades that they hold on to.
No.
And in fact, I think there was a case in or around Austin, Michael Morton, right? Where that was the pinnacle issue, where I believe the state or perhaps the investigators held some evidence.
Correct.
Created an issue. Obviously, in this case, the access to those witnesses, I think now would be more of, you had access to their statements, and the difference between 2022 and the early 1970s is the confessions or the witness statements were probably written. Unlike now, they're going to be audio, video recorded. So there's the process is different. One of the other things that got brought up, so we had the issue of the defense allegedly, or the defendant allegedly, influencing the witnesses to the point where they changed their statement and probably say, no, that's not at all what I saw, or I didn't see anything. Who knows what they said? It was enough to impact or influence the case as a whole. What was brought up, here we are 52 years later, and in this case was one of the few cases called into question, would be the present day Citizens Review Board, or the Office of Police Monitor.
Yeah,
something that we just got in 2020, 50 years after this.
Yeah, and it sounds exactly the same, like the exact same thing.
I think it is.
Yeah.
I mean, based on the stories that we got, and obviously the police union, they fought the idea and ultimately won, if you will. In 1970, it didn't happen. It didn't happen it took another 50 years.
And they're still here. They're still fighting over what this thing will look like. They still don't know what this thing will look like.
Yeah, I think there's some dispute, some back and forth on what they should have access to and what they shouldn't. And I think in a large part, a lot of that comes down to what does the Texas local government code state, what any kind of contract that the union may have with the city, etc.
One thing I think would be interesting to talk about though is to get Sean's thoughts on in our current day we're seeing all these false or bad convictions,
right? Wrongful convictions.
Yeah, there you go.
And how this might not have been that way, but the judge and the prosecutor herself decided to dismiss the case rather than possibly convict a.
I wonder if them dismissing the charge was almost groundbreaking, if you will, in the sense that it probably didn't happen much in 1970 where they dismissed the charges. I mean, they're going full steam ahead. I mean,
especially against an African-American defendant.
Right.
I mean, I don't think we can ignore the racial component in this case. And I agree with both of y'all in what you're saying. I think that, unfortunately, we're hearing more and more about defendants that were wrongfully convicted, years and years ago before, DNA evidence and other technological improvements. You hear about it all the time. You see it on the national news. And, it really, I think says a lot that in 1970, the judge and the DA felt, that they didn't have enough evidence to take this case to trial and to prove all elements of the offense beyond a reasonable doubt, and they flat out dismissed it, especially against an African-American defendant.
And I think I can't remember. I was reading on this a newspaper archive story on this case, and I can't remember if it was Ivory or dealing with Ivory or Clark that the prosecutor said that this office is not into putting innocent people behind bars or without sufficient evidence.
Yeah.
Which I thought was a credit, particularly, as you say, in that day and age and who the defendants were in their race. I thought that was rather enlightening at the time, particularly now as we see a high number, it seems like a high number of wrongful convictions over the years.
Yeah, I would agree. And I think with this case and kind of getting back to it, just looking at the offense and the charges that they were accused of, what happened next with both Ivory and Clark, maybe the police were on the right trail.
Well, I tend to believe that they certainly were on the right trail. I think it was just a matter of giving people a fair trial. I think as we will see that, I think they were on it.
Yeah, I think you're right.
As is the case with so many crimes, as time passes, it becomes a distant memory. Witnesses move on, witnesses forget, and frankly, people go on with their life. In this case, the murder of Barry Leatherman is still open. Who killed him is a question many want to know. But as you say, Jake, perhaps law enforcement had the killers in their grasp initially. In November 1983, 13 years after the murder of Barry Leatherman, a woman who was walking her dog stumbled on the body of Bill J. Phillips in a ball field in the Como neighborhood, the same neighborhood, of course, where Clark was arrested 13 years before. It was November 4th, 1983. William Sylvester Clark, Milton Punch, Bill Phillips, and a person known only as Bedford were riding in Punch's car in Como. At some point during the ride, Phillips fell victim to a robbery by Clark, according to witnesses who said, quote, Clark demanded money from Phillips and fired shots at him, hitting Punch in the hand and causing Punch to make a rapid exit from the car. Bedford also rapidly exited from the vehicle. Subsequently, Clark handed Punch some money and told him to count it. Clark directed Punch to remove the deceased body from the car and undress him. Punch and Bedford removed the body from the car and left it on the ground. They removed the deceased clothing and boots and placed them on the trunk of the car. The body was left in a ravine. They later returned to get the deceased credit union identification. Clark, Punch, and Bedford then went to Clark's house where they spent the night. The next morning, the deceased clothing was placed in a dumpster located in another part of town. Punch testified Clark told him that he would kill him if he ever told on him. Punch further testified that he did not know of Clark's plan to rob Phillips, and that he did not know Clark had a gun until shots were fired, and that he agreed to help dispose of the body and clothes only because he feared Clark would kill him if he did not. Taken from Phillips was his wallet, boots, and $250. Charged, convicted, and sentenced to life in prison for the killing of Phillips was William Sylvester Clark. A source familiar with this investigation described Clark as having a reputation for being, quote, a badass thug. With what we have learned about Clark to date, I think this is possibly the most concise description of him. In May 1986, Fort Worth PD officers were dispatched to a domestic disturbance at 2625 Prospect. When they arrived, they found Tommy J. McDonald with a stab wound to the chest. McDonald was transported to John Peter Smith Hospital, where he was pronounced dead. Charged in McDonald's death was his brother-in-law, his name Lewis Ivory. As of October 1986, Ivory was in custody awaiting trial. That verdict in that case is unknown. However, a Lewis Ivory Jr., born in 1951 from the Fort Worth area, is listed as a registered sex offender. The case disposition date was 2003. The victim, a 13-year-old girl.
Sean and I took a field trip to southeast Fort Worth.
Sean's first assignment.
His first assignment.
51 Chronicles.
Bravely handled that assignment. We went to the door. We knocked. We rang the doorbell. We left a note asking or hoping to speak to Lewis Ivory Jr. No one answered. We got a call. The female who called, who got our note, said that she was the niece of Lewis Ivory Jr. She would pass the message for him to contact us, and as of to date, he's never called. He's never provided us with his side of the story in regards to Leatherman and in regards to McDonald. The other names that we mentioned, Clarence Earl Russell was reportedly one of the witnesses. A Clarence Earl Russell with an address in the Como neighborhood was charged in 1982 with delivering capsules containing cocaine to undercover officers on multiple occasions. In 2009, it appears that the same Clarence Earl Russell passed away. Warren Kaczynski seems to have moved on to a productive life. Hopefully this was just a blip on the radar of his path in life. He never responded. And what happened to Gary Bertram Jones, we could not find out.
That concludes the complicated case involving the murder of Barry Leatherman, whose final resting place is in a plot of ground at Bluebonnet Memorial Hill Cemetery in Colleyville. Officially, his case remains unsolved, but police likely had the culprit in their grasp. Circumstances and changing stories clouded the truth of what happened on January 14, 1970, to the point of making the job of prosecution impossible. Sean, great to have you on the show.
Appreciate it, guys.
Thank you much for your invaluable input. And Jake, fist bump.
Fist bump.
Until next time, thank you for listening.
Roxo Media House.